Right. Now we are done with section 2 questions. So there we answered 4 questions in total. Now we are going to look at the most important part of the paper. You get only 2 questions. However, they allocate 20 marks each. So altogether 40 marks can be scored for these 2 questions. So extremely important. So when you are writing your answers at the exam, I would suggest this is, it differs from person to person. However, since they have allocated majority of the marks for section 3, it's always better if you can complete these 2 questions at the beginning or in the middle. What I'm trying to suggest here is, right, you can, when you start a paper, any student is nervous. It happens to all of us. The moment you start, you have a brain freezing, your brain freezes, your brain is frozen. So at once, sometimes you find it difficult to, it takes few minutes to adjust yourself to the examination environment. Now the things have changed drastically because of these online exams, right? But I believe that online exams are more student friendly, my personal opinion, though we are not familiar with it. Once you get familiar with it, you will realize, as from a student's point of view, it's more comfortable because you are at your home. So you're at you are at an environment that you're used to. Now examination environment is little different, so it takes while for you to adjust yourself to the examination environment. So therefore, when you start reading, sometimes nothing will go inside you. You will not be able to absorb things. Nothing goes inside your mind. You're just reading it without trying to understand what they have asked you. So that will be there for a moment. Therefore, I would suggest you start with a question which you are most comfortable with. If you want to start with MCQs, that's fine. But when you read the first MCQ, nothing goes inside your head, you don't understand anything, then go to the next question. Until you go to a question that you are comfortable with, you continue. Don't waste your time reading the same thing again and again. Go to the next question if you don't understand at the first instance. Then you start always section 1, 2 or 3, whatever, start with an area that you are mostly comfortable with. That will give you some kind of confidence, because you are very comfortable, these are the definite answers. You start with that, then you start writing. Then you automatically get adjusted to the examination environment, and now you start seeing things. Whenever you read, you understand, okay, this is what it means. Now when you come to that stage, I would recommend you to answer section 3, because if you start with the most comfortable one, maybe a 10-mark question or with the MCQs, and then as the second and third questions, I would say complete the 2 20-mark questions, because normally students answer the best when it comes to the second and third questions. First question, then you have, since you have started with a comfortable question, you don't have to worry. But when it comes to the second and third questions, you give your best. When it comes to the latter part, because of the time constraints, then you struggle. Therefore, answer these 2 questions, may not be as the first question, but at least as the second and third questions, complete them. Then it will boost your confidence. Okay, I am done with 40 marks now. Now I have my 10-mark questions. I don't have to spend much time, only 18 minutes. Here, for one question, you can spend 36 minutes. So for MCQs, you have to spend less time. You can do it even at the last moment because you have 4 answers to pick, right? So without panicking, then you will be able to answer. So use an approach like that, then you will be able to manage your time properly while securing the maximum possible marks at the exam. Okay, let's start section 3, question number 6. So both questions are compulsory. Total marks for section 3 is 40 marks. Recommended time for the section is 32 minutes. That means 36 minutes each for each question. So question number 6, let's read it. Recently, Suren's father gifted a 2-acre land to him. The deed of gift was written in Suren's name. Suren intends to use this land to generate organic fertilizer. Now, a good time to discuss about a question like this actually. We have a lot of discussions going on with regard to organic fertilizer. In order to undertake this task, S wishes to, because it has created an opportunity now. Because since we have stopped bringing non-organic fertilizer, now there is a demand for organic fertilizer. So it's a booming industry. So it's a business that you can invest in. So in order to undertake this task, S wishes to incorporate a private company under the Companies Act number 7 of 2007 Act, together with his friend Ruan. Prior to incorporating this company, S has consulted you to clarify the following doubts he has. Okay, so this is the situation. Even though it's 20 marks, it's not a lengthy scenario. Very simple, straightforward, only 2 paragraphs, and based on that they are asking you to address 3 situations. What are those? If R refuses to join as a shareholder, can S form this company as a sole shareholder? He wants to do this business with his friend Ruan, but what if Ruan refuses to join? What if Ruan refuses to join as a shareholder? In that case, can Suren commences the company on his own? In other words, can you start a single shareholder company? The moment you hear this word single shareholder company, you should know the relevant provision of the Companies Act, and you should know whether it is possible for you to start a single shareholder company or not. You should know that. I can give you the answer straight away. Yes, you can start a single shareholder company under number 7 of 2007 Companies Act. If you look at the old Companies Act, it was not possible. Even to start a private limited company, you had to have 2 members. But now, under 2007 Companies Act, you can start a company with a single shareholder. It's possible. You can't just say single, it is possible. You have to support your answer with the relevant section. Extract the relevant parts from the section and explain why you say that it is possible to start a single shareholder company. Then, after incorporation of the company, will the 2-acre land belonging to Suren be treated as a land belonging to him or to the company? Now, what is the relevant principle here? We have a doctrine called separate legal personality. I explained this when I was referring to some other question. I think Foss versus Harbottle rule. I was referring to this concept, separate legal personality, veil of incorporation. The moment a company, the moment you incorporate a company, it creates a veil. A veil means a cover between the company and its shareholders. The moment you create a company, moment you incorporate a company, it creates a veil, a barrier between the company and its shareholders. The company and the shareholders are not the same. So, I'll explain it like this. I can buy shares of any listed company anytime I like through the Colombo Stock Exchange. Let's assume I have bought 1,000 shares of Commercial Bank PLC. That makes me a shareholder or else an owner of Commercial Bank PLC. Does that mean I can own the properties belonging to Commercial Bank PLC? Is that possible? I have bought 1,000 shares of Commercial Bank PLC. I am a shareholder of the company. Can I go to any commercial bank branch and say, here, I own Commercial Bank, therefore this property belongs to me. I have some ownership over this property. No way. You have an interest in Commercial Bank PLC since you have bought 1,000 shares, that's all. You do not own any properties of Commercial Bank PLC because the company is a separate person. If company has bought a property, if Commercial Bank PLC has a branch in Borella or here somewhere in like in Borella, Rajagiri or whatever place, even in another country, that property belongs to Commercial Bank PLC, not to the shareholders of the company. Likewise, if I own a property, I may allow the bank to use my property, but if it is under my name, the property belongs to me, not to the company. What I can do is here, in this situation, to generate organic fertilizer, I can give my land. Land is owned by me. Company can only use the land. Company can only use the land. For that, the company may pay me a rent. Company may pay me a rent, or else some other provision can be, parties can have a different arrangement. But the simple way of explaining, I allow the company to use my land to generate organic fertilizer. They can pay me a rent, or else I can even provide free of charge. But the land belongs to me in this situation. Here, the deed of gift was written in Suren's name. Therefore, even though you have allowed the company to generate organic fertilizer using the land, Suren will remain as the owner of the land until such time Suren decides to transfer the ownership of the land to the company. If Suren wants, he can sell that land to the company, or else he can even gift that land to the company. Then the company will become the owner until such time Suren will remain as the owner. So I have given the answer to that question as well actually. Once incorporated, can the company continue its existence? Once incorporated, the company can continue its existence if one of its shareholders dies. Now, what is the relevant concept here? Perpetual succession. Something that you would have learnt at the very beginning of your syllabus. The characteristics of a company, the features of a company. Once a company is incorporated, the company is a separate person. Company can own properties on its own name. Company can take legal action against other parties. Other parties can take legal action against the company. Company can obtain loans under its own name. That is because a company is a separate person. Think of a company like Coca-Cola, John Keel's Holdings. They have been in this industry for more than 100 years. They have been in the market for more than 100 years. The people who started Coca-Cola or else John Keel's Holdings, they are no longer there. They are gone. They're long time gone. They have died long time back, more than 100 years ago. But the company is still in, the company is still in existence. Is still in existence. That is because a company has something called perpetual succession. The shareholders may die, the shareholders may leave the company. If I am not, I can buy shares of Commercial Bank PLC as I mentioned. If I want, I can sell it to someone else and leave the company. Will that have an impact on Commercial Bank PLC? No. Assume someone owns 90% of the shares of Commercial Bank PLC. Even though he decides to sell his shares, a new shareholder will come into play. Company will remain as it is. So shareholders may die, shareholders may leave. Company will continue to be in existence because a company has perpetual succession until the shareholders of the company decide to wind up the company. So even though we say perpetual succession, the company can continue to be in existence for even 1,000 years. But at some point, if the shareholders decide to wind up the company, then the company will come to an end. Until such time, a company has perpetual succession. So while I was reading, I explained it. Once incorporated, yes, it's possible. Then required. Explain the correct legal position to assess queries. What are the queries he has? 3 queries. What happens if R refuses to join? Can he form a single shareholder company? After incorporation, what happens to his land owned by him? Once incorporated, can the company continue its existence if one of its shareholders dies? So I explained it, but now let's look at the relevant provisions from the Companies Act and from the textbook, right? So here you can see learning outcome, as I told you here at the very beginning, 1.1.2. It's about separate legal personality, perpetual succession, and the features of a company. Study text here, pages 4 and 5. Though you studied them at the very beginning, now it has been tested for 20 marks. Other references, section 4. Let's look at section 4 here, because that is where it explains how you can start a single shareholder company. So let's look at that part now. Okay, here section 4 subsection 1, subject to the provisions of subsection 2, any person or person may apply to incorporate a company other than a company limited by guarantee by making an application for the same to the registrar in the prescribed form signed by each of the initial shareholders. The relevant form is form number 1. And here this section is not applicable to companies limited by guarantee, because today we looked at there is a separate part applicable to companies limited by guarantee, together with the following documents. So those are the documents that we have to submit. But here, to answer this question, answering this question, let's look at section here. Section 3 explains the different types of companies available. So we have limited companies, unlimited companies, and company limited by guarantee. And then here it explains the method of incorporating a company. Now basically it says, now I must tell you, when it was drafted, initially they didn't have any expectation to allow any individual to start a single shareholder company. They wanted it to allow, they wanted to allow this for the government to start single shareholder companies. But later when they introduced it, they included any individual, any person can start a single shareholder company. Now here let me show you that part, then it will be clearer to you. Here a company shall have not less than 2 shareholders. Now this is the relevant section. Section 4 subsection 2. Now read this. A company shall have not less than 2 shareholders. So they starting the section stating every company should have at least 2. That's why it says shall have not less than 2. That means you have to have 2 shareholders at least. But that means provided that a company may have a single shareholder where such single shareholder is the secretary to the treasury. That's why I told you initially they wanted to give this opportunity of starting single shareholder companies only to the government. That means secretary to the treasury who's holding shares on behalf of the government of Sri Lanka. So they wanted to give the opportunity to the government of Sri Lanka to start single shareholder companies if necessary. In that case, the secretary to the treasury is the person who should hold that share. But later they added this part. Therefore, now any person, any individual, any company can start a single shareholder company. That means you can start a company where you own 100% of the share capital of the company. Any company can start another company, that means a subsidiary, where they own 100% shareholding of the company. That is what we call single shareholder company. Accordingly, in terms of section 4 subsection 2, yes, it is possible for Suren to start a single shareholder company. So let's look at the answer and the answers to the other parts here. Section 4 subsection 2, you can reiterate this section. You can look at section 4 subsection 2. You can reproduce that section in your answer and then you can explain. So that's the beauty of this paper. Since it's an open book test, you can look at the Companies Act, extract the relevant parts from the Companies Act, and you can support your answer with those extracts. In company law, so that's the answer for the first part. You refer to the relevant section, you can reproduce, and then you can say, yes, Suren can start a single shareholder company. Then the second part of the question was whether, what happens to the land? So I explained it. Then you have to refer to the separate legal personality principle and you have to explain the features of the separate legal personality. One of the important features is the company becomes distinct and different from the shareholder or shareholders of the company. Therefore, company can own assets. The company can own assets on its own. The company can own assets under its own name. Whereas the shareholders' assets do not belong to the company. If the company owns an asset, that doesn't belong to the shareholders. Likewise, if the shareholders own assets, those are their personal assets. They are owned by the shareholders, not by the company. So accordingly, you explain that. Then the third part of the question was whether the company can continue to be in existence even though the shareholders die or leave. Yes, it is possible because a company has a perpetual succession. Accordingly, until such time you make the decision to wind up the company, or else it can be a situation where you have started a company to achieve a particular objective. So now you have achieved that objective. In such situation, also you can bring the company to an end, because there's no point, since you have achieved the objective if you have started the company to achieve a particular objective, if you have achieved it already, then you can bring the company to an end. Or else, even though you have not achieved it, if the shareholders have decided to wind up the company, you can bring the company to an end. Until then, even though the shareholders die or leave, the company will continue to be in existence. Right. So here, this means that unless the company specifically wound up or the task for which it was formed, has been completed, the company will continue to be in existence for an indefinite period of time. We call it perpetual succession. We call it perpetual succession. So yes, Suren's company can continue to be in existence. Okay, so that's the answer for part A of question number 6. So there they have allocated 10 marks. Then let's look at the part B of question number 6. So that's how they have allocated 20 marks. There are 2 parts. Now, second part of it, R and S have agreed the name their prospective company as Organic Sri Lanka. Organic Sri Lanka. So R and S, they want to start a company, and for their company they have decided to use the name Organic Sri Lanka. Next, they submitted the duly completed documents required to incorporate this company to the Registrar of Companies, ROC. However, ROC refused to accept these documents. The moment you saw the first sentence, the moment you look at the first sentence, you should know that there is a problem here. ROC refused to accept these documents, saying that the first step in incorporating a company has not been followed by R&S. Further, a clerk at ROC has also indicated to R&S that it is very unlikely that the proposed name will be approved by the registrar. So, you should know this question is with regard to determining the name of a company. R&S have posed the following queries to you. So, this actually narrows down the answer. It's a good thing. So, you have to just answer the queries. What does the clerk at ROC say that the proposed, why does the clerk at ROC say that the proposed name may not be approved? So, when you are writing the answer, write these queries. You can write the query, and then under that you can write your explanation, write your answer. Even for the previous one, take 3 headings, and under each heading you explain your answer rather than just explaining everything at once, at one go. Now, if you look at the previous question, which I forgot to mention, now there were 3 parts to part A. So, take a separate heading, under that explain whether he can start a single shareholder company. Then second query, who will own the land? Then the third query, whether the company can continue to be in existence even though the shareholders die or leave. Likewise, here there are 2 queries. So, you query 1, you can say query 1, write it down. What does the clerk? So, I mean, you don't have to write the whole thing. So, you can say query 1, proposed name of the company. Under that you explain it. Then the second query, what must R and S do now before resubmitting the incorporation documents that were rejected earlier? So, there are 2 queries with regard to this. Separately address them while referring to the relevant provisions. Now, they have allocated 10 marks for both queries actually. Let me give you a brief explanation. When you are forming a company, what is the very first thing that you have to do? You have to get the name approval. You have to get the name approval. Once they approve the name, they give you a name approval number. Now, I don't have time to explain the whole procedure, but if I had time, I could have referred to the relevant registration forms. I could have visited to the Registrar of Companies website. Normally when I deliver lectures, that is how I do it. But here I have limited time. I have to limit myself to the questions that you have been given here. But otherwise, we should refer to the relevant form. When you look at the form number 1, you can see there is a box which says name approval number. So you can't actually submit an application form to the Registrar of Companies without first obtaining the name approval. That's the most important thing. Incorporating a company is like giving a birth to a child. The company's life cycle is also very much similar to the life cycle of an individual. We are born to this world. Likewise, a company is born to this world. That is what we call incorporation. When a child is born to this world, what's the first thing that we do? We give a name. So that's how, that's the existence of the, now I have a name. All of you have names. So from that's how we identify a person. Likewise, when a company is born, first of all, that company should have a name. Then the company has a life, and finally, the company has a death. That is what we call winding up. So anyway, here, the prerequisite before submitting form number 1 to register the company, you must first obtain the approval for the name that you have decided. Now in this instance, it is clear the Registrar of Companies has not given the approval. So then you have to explain why have you not been given the approval. Why does clerk RO say that the proposed name may not be approved? What does R&SO do now before resubmitting the incorporation documents? You can't submit incorporation documents if the Registrar of Companies has refused to accept these documents saying that the first step in incorporating, you have straight away submitted the documents to the Registrar of Companies. Registrar of Companies can't accept it because you have not fulfilled the first part of the registration. What is that? Name approval. Now everything is done online. The Registrar of Companies, if you visit the website, you can see, you can request for a name approval online. You make the payment, you state the name that you want to use, and then you get a name approval number. With that, you can submit Form 1 and other relevant documents for the approval of the Registrar Company. So the name approval is the first step. Now without doing that, you can't submit the other documents. So that is why the Registrar of Companies has refused to accept the documents, saying you have not fulfilled the first part, that is name approval. Now a clerk of this Registrar of Companies, he says, you have slowly asked him, okay, will we be able to get the approval for this name? So the clerk of ROC, knowing the whole process, he says, through experience, it is highly unlikely that you will be able to get the approval for the agreed name, Organic Sri Lanka. So then you have to explain why it will not be possible for you to get the approval for the current name that the two shareholders have agreed, Organic Sri Lanka. So you have to refer to the relevant sections of the Companies Act and explain why it is not possible. So the moment you see this, you should be able to get the idea. Normally, unless you get the minister's approval, you can't use the word Sri Lanka. You can't use the word Sri Lanka unless you get the minister's approval. And on the other hand, the moment you use the word Sri Lanka, it can be a misrepresentation, because other parties, the general public, may come to the conclusion, okay, this organization is having some kind of a link with the government, because the moment you see the word Sri Lanka, people may think, okay, they have some kind of a link with the government. So it's a misrepresentation. Therefore, the Registrar of Companies will not anyway give approval. Other than that, to use the word Sri Lanka, you have to get the minister's approval. And apart from that, this is not how you should write a name of a company. It appears that they are going to start a private limited company. In that case, when you are writing the name, with the name, you have to, within brackets, you have to say private or PVT. And then you have to say limited, private limited company. If at all, assume that you have got the approval from the minister, then Organic Sri Lanka Private Limited. So the word private should be there within brackets. Otherwise, you can use the shortened form PVT, and after that you have to say either limited or LTD. So when you are writing the answer, you have to do a very simple thing. Refer to the relevant provisions of the Companies Act. You can extract the relevant parts from the Companies Act, and then you can support the answer. So let's look at it. Here the relevant sections are extremely important. So the learning outcomes 2.2.2, read the pages 28 and 29 with regard to name of a company, and then we have to refer to section 6 and 7 of the Companies Act. Now we are going to look at those sections. Right. Here, this is the basic requirement, section 6. You can't just write a name. With that, you have to say whether it's a private limited company, public limited company, or whether a company which is not listed in the Colombo Stock Exchange. So this is how it goes. Now, if they are going to start a private company, after the name, within brackets, you have to put private, and after closing brackets, you have to use the word limited. If you have written the full word private, then after brackets also you have to write the full name, full word, basically limited. But if you want to use the abbreviation, the short form, in that case, within brackets you can say PVT, and after closing brackets you have to say LTD. And if it is now here it's the part B is applicable actually, but since others are there, if it is a listed company, if it is listed in the Colombo Stock Exchange, then you have to say, let's say ABC Public Limited Company, you can write the whole thing, or else the abbreviation PLC. If it is not a private limited company, or if it is not a company limited in the stock exchange, then you have to write the name like this. That means ABC Limited or ABC Ltd. That means it's not a private limited company and also not a company listed in the stock exchange. That's what it indicates. So now the purpose of having a name, people should be able to understand the status of that company. The people should be able to understand the nature of that company. That's the whole purpose. We also have a name to identify that person from someone else. For identification purpose only we have a name. So that is why there are some strict provisions with regard to the name of a company. Then that is how you should write the name, and apart from that you can't use whatever name you like. The first important thing is you can't pick a name which is similar or identical to an existing company's name. You can't, that's the general rule. You can't pick a name of a company which is identical or similar to an existing company. How can you find it out? Very simple. You go to the Registrar of Companies website. You can do a name search. You can do a name search. Whatever the name that you have in your mind, you can type it under that search name window. I mean, you can go there. There's a category, platform. There's a window open when you say search name, and there when you search the name that you have in your mind, then it will give you some results which will explain whether the name that you have selected is name identical or similar to an existing. So then you know whether it has already been used. If it is already been used, then ROC may not approve it. That is one thing that you have to do whenever you submit a name for approval. Before submitting a name for approval, you just check whether it is a name similar or identical to an existing company. here part 7.1a. Then there are certain words that cannot be used. So I am not going to explain one by one, but here I will straight away pick the relevant one. Part 2. It says, except with the consent of the minister given having regard to national interest, no company shall be registered by a name which contains the word. These are the words that you have been given. Look at part D under that. You cannot use the word national, state or the word Sri Lanka, which is in the opinion of the registrar suggests that are calculated to suggest any connection with the government or any government department. So it will be misleading in the opinion of the registrar of companies. Therefore, for such names, you have to get the approval of the minister. Therefore, it is highly unlikely that the registrar will give the approval for such, if you are going to use the word Sri Lanka, because of these reasons, you can't just give an answer. Because of the reasons that I stated, you may not be able to get the approval, because first you need to get the minister's approval if you want to use this word at all. And also mention about 7.1a also, because you cannot use the name which is identical or similar to the name of any other company or any registered overseas company. So let's look at the answer now. Okay, so section 6 of the Act states that the name of a private company must end with the words private limited or by abbreviation PVT limited. Then 7.1 it says of the Act states that a company shall not be registered by a name which is, which is identical to the name of any other company or of any registered overseas company. Now, from where have you extracted it? You have the Companies Act with you. You go to 7.1 and then you just reproduce the section, and for that reason you have to say, when you are selecting a name, you cannot pick a name identical to an existing company. Then 7.2, to be precise, you can mention 7.2d, subsection D. You reproduce the section. It says, except with the consent of the minister in charge of the subject, no company shall be registered by a name which contains the word Sri Lanka. Okay, so that is the answer for first query. Then they are asking another one. Let me quickly show you that part also. It's a very straightforward one. That is, what must R and S do now? Because Registrar of Companies have refused to accept the document submitted stating that you have not fulfilled the first step in incorporating the company. What's the first step? Name approval. Suggest a name to the Registrar of Companies and obtain name approval. So that's the first thing now you should do. Before resubmitting the incorporation documents that were rejected earlier, what you should do? Decide a name, decide a feasible name. Now we know Organic Sri Lanka, the word Sri Lanka cannot be used without the consent of the minister. So are you going to get the consent of the minister? Highly unlikely. Then what you have to do is pick another name. When you are picking a name, go to the Registrar of Companies website, do a name search. If you want, you can even visit the Registrar of Companies. Now you don't have to do it because everything happens online. Online, you can do a company name search and see whether the name that you have picked is identical to a name of an existing company registered here or overseas company. Then get the name approval. Once you get the name approval, only you can submit the relevant document. So let's see that part now. It's a small part in your answer actually. So what you should do next, they must first decide on a new name for the proposed company, because it's highly unlikely that you will get the approval for the agreed name. So decide a new name which is within the framework mentioned above. So you have to write the name of the company with the abbreviation PVT Limited or Private Limited, and then it should be a name acceptable to the Registrar of Companies, and it should not be a name where you require the minister's consent, and it should not be a name which is identical to a registered company. In that case, get the approval for the name here, then apply for and obtain the approval of the registrar for this name. Then the registrar gives you an approval number. Without that number, you can't anyway fill form number 1, that is incorporation. Incorporation form number, incorporation application is known as form number 1. In that form number 1, you have to fill the name approval number. So obviously you can't submit it without that name approval number. So that's a first thing that you should do. After that only you can submit the other documents. So with that we conclude actually question number 6, both part A and B. And then let's look at question number 7. So that is actually the last question that you get under section 3. With that we conclude 40 marks. So let's read it. Bimsara Private Limited, BPL, has been a leading exporter of natural flowers to Europe since 2005. The present shareholders of BPL are as follows. Okay, there are 3 shareholders. Let's see. Bandula, 200,000 voting ordinary shares. There are different types of shares, ordinary shares, preference shares. When it comes to ordinary shares, some ordinary shares do not have voting rights. I mean, by default, normally ordinary shares have voting rights. 1 share, 1 ordinary share, 1 vote. But preference shareholders, we know that they don't have voting rights. Ordinary shares, normally by default you have voting rights, but it is possible for the company to issue ordinary shares without voting rights. Non-voting ordinary shares can be issued. So here Bandula is a ordinary shareholder with voting rights. Sara is having 150,000 shares, 150,000 ordinary shares with voting rights. But look at Manjula. Manjula is having 100,000 non-voting preference shares redeemable at the option of the holder. One thing, they are not ordinary shares. Then the other thing is, anyway, they are not voting shares. Normally preference shares are anyway not voting. They don't have any voting rights. Here, there can be different types of preference shares. Redeemable preference shares, irredeemable preference shares. So here, these preference shares are redeemable. What do you mean by that? Now remember this. If you buy an ordinary share, let's say you pay 100 rupees and buy an ordinary share, can you at some point, can you demand from the company, can you compel the company to pay your money back? Can you ask the company here, I don't want your shares, take my shares and give me my money back? Can you do that? As an ordinary shareholder, you can't do that, because ordinary shares are normally irredeemable shares. That means the company has no obligation to return your money, in particular if you are an ordinary shareholder. This connects with the concept limited liability also. Why do we say a shareholder has a limited liability? Because his liability is limited to what he has invested in the company by purchasing ordinary shares. If I have purchased ordinary shares worth of 100,000, that means my liability is limited to 100,000. In other words, I don't have to bring anything extra to settle the liabilities of the company. But that also means my liability is limited to 100,000. In other words, I may lose that 100,000 if the company has a problem of settling their liabilities. I don't have to bring anything extra, but I have the risk of losing that 100,000 that I invested in the company. Therefore, we say my liability is limited to 100,000 rupees that I have invested. That means I may lose that 100,000. That also shows the company has no obligation to return that 100,000 to me. If the company is struggling to settle the liabilities, company has no obligation to pay that money back to me if I am an ordinary shareholder. But if I am a redeemable shareholder, especially in this instance, redeemable preference shareholder, that means I can take my money back. Shares can be redeemed in different ways. One way is, okay, assume a situation, the company has issued some redeemable preference shares for a period of 2 years. What does that mean? What does that mean? What does it mean? I have bought preference shares for a period of 2 years, and it says, as a part of a condition, it says after 2 years, if the company wants, the company can repurchase my preference shares and return my money. Return my money. Alright? That's one thing. That is what we call redeemable at the option of the company. But here, now redeemable at the option of the company means after 2 years time, according to my example, the company can decide whether to return my money or not. Whether to return my money or not. Another way of doing this is redeemable at the option of the shareholder. That means, according to the same example that I took, let's assume the preference shares have been issued for a period of 2 years. Redeemable at the option of the shareholder, that means after 2 years time, I can demand, I can compel the company to buy my preference shares and return my money. That is what we call redeemable at the option of the holder, the shareholder. After a specific time period, as agreed at the beginning, I can ask the company to buy my shares back and return my money as agreed. So that is what we need to understand when answering the question. Now let's look at the queries that we have to address here. So let's see. BPL has adopted the model articles, Schedule 1 to the Companies Act. You know there are 13 schedules to the Companies Act. Now here Schedule 1 is model articles. I will quickly explain what you mean by model articles, because to answer a question you should be familiar with all these things. Now when you are registering a company, you have to produce your articles of association. That is the constitution of the company. Now Sri Lanka as a country has a constitution. We say the constitution is the supreme law of the country. You cannot make any law in this country if it violates the constitution. Therefore, no law can be made above the constitution of the country. Every law that you prepare should be in line with the constitution of the country. Likewise, a company also has a constitution. That is what we call the articles of association. So whatever the decisions made in a company, basically the articles of association, which is the constitution of the company, regulates or governs the behavior of the company. Normally articles of association includes the objects of the company. It includes how the directors are appointed and removed, how auditors are appointed and removed, how the secretary can be appointed and removed, how you should conduct shareholder meetings, what is the notice period that must be given, the procedure that must be adopted when you are conducting board meetings, and not only that, how to the way that you should distribute dividends of the company. What if you are going to buy back the shares? How you are going to issue redeemable shares? If the company is going to issue shares, who has the authority to issue shares? The type of resolutions that can be passed, and the procedure and the notice that must be given when you are passing a resolution. How to wind up a company. Everything that is relevant to govern a company can be included in these articles of association. So that is why we call it the constitution of the company. Then a question arises, how can we draft an articles of association? Okay, think like this. Now you have to go for a function. Let's say you have to go for a wedding. Now for that you need to buy a dress or a suit. Now if you are going to buy a suit for a wedding, you have few options. One option is you can buy a ready-made suit. You can go to a place like Hamedia's or any other place, and they have ready-made ones. You go to Hamedia's and you fit on and you see whether it suits you, and accordingly you can purchase it. I mean, no hassle-free actually. We call it, you can buy it off the shelf. It's already there. That's one thing. Or else what you can do is, you go to a tailor and tailor will take your measurements and the tailor will stitch a suit according to your measurements. When you buy from Hamedia's or some other place, it is not actually done according to your exact measurements. That is there. But you can, find something which comes closer to your measurements. But if you go to a tailor, the tailor will do it exactly according to your measurement. Or else, there's another option. That is, you can buy a suit from Hamedia's or some other place and you see that it not perfectly suits you. It doesn't perfectly suit you. Therefore, you take that suit, maybe you can ask Hamedia's, they also do the tailoring part, or else you go to some other tailor, you go to some other tailor and you ask him to alter it according to your measurements. So three options. You buy off the shelf, something which satisfies or something which come closer to your requirements, or else you go to a tailor and get it stitched according to your measurements, or else you buy something otherwise you buy something from a place like Hamedia's and then you go to a tailor, you ask them to alter it according to your requirement. Articles of association also something like that. You have three options. One is, like you go to Hamedia's, you can adopt the model articles given as a schedule to the Companies Act. Schedule 1 of the Companies Act Schedule 1 to the Companies Act gives you the model articles. If you want to incorporate the company quickly, if you don't have time, now tomorrow is the wedding, so then you don't have time to go to a tailor. Likewise, if you are in a rush to form the company, then what you can do is, you straight away use the model articles as your own articles and start the company. Then the model articles becomes your own articles. Then after that you have to comply with the model articles. If not, you do articles according to your requirements. You go to a company secretary, might be a chartered accountant or as a lawyer, and you ask them to prepare an articles for your company according to your requirements. It's like you go to a tailor to get a suit done. So there, it's nothing to do with the model articles. You tell, these are my requirements, draft an articles of association according to our requirement. The third option is, okay, you don't want to adopt the model articles as it is. Then what you can do is, you take the model articles as a basis and you remove and add whatever you want. Then you alter it, alter the model articles according to your requirements. Whatever the parts that you don't want, you remove it, and whatever the parts you want to add it, you can add it. And then you can customize it like that. That's the other option available, right? So anyway, the question says this company has decided to adopt the model articles, right? The current economic situation in the country has resulted in BPL making continuous losses. As a result of the continuous losses, M has given notice to BPL that he wishes to redeem his shares, that M is the person who's having, that is Manjula. M is the person who's having redeemable preference shares. He has every right to redeem, he has every right to ask the company to pay for his shares, because if it is permitted by the model articles. Anyway, let's look at that part, but first we'll read the part. As a result of the continuous losses, M has given notice to BPL that he wishes to redeem his shares at the end of the 14 days from the date of the notice. So he has given notice to the company here. From the date of notice, within 14 days, you have to return my money. However, the directors of the company have refused this request, saying that BPL does not have sufficient cash to pay. This has created a deadlock situation at BPL. Deadlock means it's a situation where the company cannot forward. A deadlock. A lock has been put where, now think of a situation like this. You have put a lock. No one can go out and no outsider can come in. You can't go out, others can't come in. We call it a deadlock situation. So if a company is in a deadlock situation, that means the company cannot move forward. The company cannot make decisions. So the company has become stagnant. The company cannot move forward. We call it a deadlock. So anyway, that is not that important to answer the question. In order to resolve this deadlock, both the directors of BPL and M have sought your advice. So they are asking, what can we do? What can we do here? Because even though he has asked for money within 14 days, we don't have money to pay. So M wants his money, directors don't have money to pay, so they are asking, what can we do in this situation? You have to give a solution. Explain. The key word here is explain to the parties the correct legal position in relation to this redemption. I will explain it and then we will look at the answer. So here I have explained all the necessary parts for you to answer the question. One thing, M has the right. They have adopted model articles. Now certain companies, if they want, through their articles, they can restrict the company's power to issue redeemable shares. Through the articles, if the company wants, they can put an article stating here, the company has no right to issue redeemable shares. Then the company can't do that. But if the company has adopted model articles as it is, in the model articles, you have to look at the model articles. But when you look at the model articles, you will see the model articles of the company has no provision, has no article which prohibits or which restricts a company by issuing redeemable shares. Therefore, this company has the right to issue redeemable shares since they are not prohibited by the model articles. So, the redeemable shares are valid. And you have issued the redeemable shares at the option of the shareholder. That means Manjula can at any time ask the company to pay his money, and accordingly he has given 14 days asking them to pay his money back within 14 days time. So he has the right to ask for his money. Then a question arises, what if the company refuses to pay that money? Remember, the company is not paying here because they have a financial difficulty. You have Manjula has the right to ask for his money. That is a valid request. If the company fails to pay that money within 14 days, then what happens according to the Companies Act? Until, Manjula's shares will be cancelled. After 14 days, Manjula's shares will be cancelled. And it will create a liability for the company to pay him. Within 14 days, if they pay, what happens? Anyway, his shares will get cancelled and he receives money. If they don't pay, the shares will get cancelled still, and then until such time the company pays him, Manjula should be considered as a liability for the company. So the company now has an obligation, a liability to pay Manjula. Actually, in this situation, he will be treated as a unsecured creditor. Who's an unsecured creditor? There are mainly two types of creditors, secured creditors and unsecured creditors. Now, assume, I believe that you're familiar with mortgage loans, UGAS. Now, assume the company has obtained a loan from a bank. Bank says here we can't give loans like that. You have to give us some kind of a security you have to give some kind of an asset as a security, because if you don't pay us, then we can sell that asset and recover the money. That's what we call a mortgage. Now that is an example for a secured loan. The bank has no problem, because if the company doesn't pay or doesn't settle the loan, the bank can sell that property which has been given them as a security and recover the money. Assume you have taken a housing loan. Then what happens? They give you the loan to build the house. If you don't settle the loan, what happens? They will sell the house and recover the money. So there the bank is a secured creditor, because they have some kind of a security to recover the money. If you have lent money to someone without a security, that means if the company doesn't pay, you don't have any asset or security to recover the money. We call them unsecured creditor. Until the company pays you, there's no way that you can recover the money because you have no security or asset given for you to sell and recover the money. It's not possible. We call them unsecured creditors. So that is the situation here. Yes, he has the lawful right to, so you have to explain, there are no restrictions for the company to issue redeemable shares since they have adopted model articles, and then Manjula has the right to request for his money, because these are redeemable preference shares at the option of Manjula. So he has requested for his money, asking the company to pay within 14 days of the notice. If the company doesn't pay, then his shares will be cancelled and he will be treated as an unsecured creditor until such time the company makes the payment. So that's how it goes. So anyway, let's look at it. So you can see the learning outcomes. 3.3.1, pages 52 and 3, you have to read them. And the relevant sections are section 66 and section 68. And I will read the answer, and then after that we will look at the two sections also. So the Act allows a company to redeem its shares, company to issue redeemable shares, unless its articles association restricts such redemption. But model articles do not impose any restriction since they have adopted it. They can freely redeem the redeemable shares. So no restriction will be placed on it to redeem its shares. The shares will then be deemed to be cancelled. Even though the company doesn't pay, after 14 days, the shares will be cancelled with effect from that date after 14 days. So he has given 14 days notice. So after 14 days also, if it is not settled, it is deemed that the shares have been cancelled, though the payment has not been paid. Until such time the payment is made, then Manjula should be considered as a unsecured creditor of the company. So now let's look at section 66 and section 68 also, because it's stemming from those sections. Okay, here redemption of shares. For the purpose of this act, a share is redeemable if the article of the company makes provision for the redemption of the shares by the company. So the article of association should enable the company to issue redeemable shares. So redeemable shares can be issued in 3 different ways. I told you. One, at the option of the company. That means then only the company can decide whether to pay money back. The other one, at the option of the holder of the share. Then the shareholder at any time can demand the company to pay his money. That is what happened in this situation. So Manjula comes under 66 part B. The other one is on a date specified in the articles. This specifically says after 2 years your money will be paid. So then after 2 years the company has to pay. For a consideration, so that is specified or to be calculated by resident. Yeah, so anyway, that's how they can, the value can be determined. That is not relevant here, but you can reproduce the relevant parts of the section and you can explain the company's articles of the company should enable for you to issue redeemable shares. So the model articles permit you to do that, and here the redeemable shares are issued at the option of the holder. Therefore, he can make a valid claim to recover his money as stipulated in the question. Then 67, redemption option of company. So then after that explain, what if you have issued redeemable shares at the option of the company? Then applicable section is 67. But here we are referring to a situation where the shares can be redeemed at the option of the holder. For that we have to look at section 68. Here, redemption at the option of the shareholder. So you can refer to this section. You can extract whatever the relevant parts from the section and reproduce in your answer, and then you can come to a conclusion very easily. Where a share is redeemable at the option of the holder of the share and the holder gives proper notice. Here, yes, he has given proper notice. He has said, I am giving notice within 14 days you have to make the payment. Proper notice to the company requiring the company to redeem the share. Then, what is the responsibility of the company? The company shall redeem the share on the date specified in the notice. If no date is specified, on the date of receipt of the notice. So, here he has specifically stated within 14 days you have to settle it. If no exact date has been given, then in that case, the date you receive the notice, you have to make the payment. That's the obligation of the company. Company shall redeem. No other choice. They have to do it. The share is deemed to be cancelled on the date of redemption. So here it comes from section 68 1b. So after 14 days, if it has not been settled, then it is assumed that the share has been cancelled on the date of redemption, that is on the 14th day. Then what happens? From the date of redemption, the former shareholder ranks as an unsecured creditor. He is no longer a shareholder of the company. He becomes an unsecured creditor of the company for the sum payable on redemption. Right? So that is how you should answer that question. So you have to mainly refer to section 56 and 58 of the Companies Act. So if you know from where to find out the section, where to locate the section, you can extract the relevant parts. You can even reproduce the relevant parts from section 66 and 68, and then you can come to the conclusions. So my explanation was purely based on these sections, nothing else. So since it's an opening book test, so since you have the Companies Act with you, use that as a, get the maximum out of it. Then let's look at part B of question 7. With that, we will be able to conclude section 3. So let's see part B of section question 7. Right. In order to make a BPL profit-making entity again, its directors have proposed to change the existing object clause of BPL so that it can undertake to manufacture of face mask and medical equipments. Actually, personally, there are companies known to me, they switched to this production line. I mean, switched to in the sense, while they have been manufacturing certain, their usual products, I know most of the companies decided to switch to manufacturing of face mask and medical equipment, sanitizers, hand sanitizer, disinfectant, likewise. Now, most of these companies, they have their own production line because they saw it as an opportunity. So anyway, that is not relevant to the answer, but it's a practical question that you have been given because of this COVID-19 situation. However, due to the prevailing travel restrictions, the directors of the company do not. Now, these are very practical questions. Your examiner has put very practical questions. We had a lockdown, we had curfew, so during that time period we could not travel. Even now we can't travel from one province to another province, though people still do it. So the directors of the company do not intend to have a meeting. So because of these travel restrictions, they can't have a physical meeting. Do not intend to have a meeting of either the directors or the shareholders to pass the resolution for this change. Now, you can't, now if the company has an object clause, can you do something which is not covered by the object clause? No, it is not possible. You can only do things which are covered by the objects clause. If you want to do something else like undertaking to manufacture face mask and medical equipments, now no, it's like this, I'll put it this way. Unlike the old Companies Act, it's not compulsory for you to have an objects clause. Under the old Companies Act, you are very well aware, you can't start a company without having an object clause. So if you are starting a company to manufacture garments, and if that is your object, then you could not do anything other than manufacturing garments. If you do that under the old Companies Act, the transaction becomes void. You call it ultra virus transactions, beyond powers, ultra virus, beyond powers, right? But here, it's not like that. Under the new Companies Act, you have the option. Earlier, it was mandatory. You could not start a company without an objects clause. But now what happens is, you have the option to start a company with or without objects. If you want, you can start the company without objects. If you start the company without objects, then there are no restrictions. You can do whatever business you like. While you are selling sugar, you can sell disinfectants. You can even start manufacturing garments. You can do whatever you like if you have started the company without an objects clause. But if you have decided to start with an object clause, that will restrict your ability to do business, because then you have to limit yourself to the business that you have mentioned as your object in the Articles of Association. Therefore, if you want to do a business which is not covered by your objects, then first of all, you have to change your objects of the company. You have to put a new object stating that the company can undertake to manufacture face mask and medical equipments. So a new object must be included. For that, you have to change the existing objects. That means you have to alter the Articles of Association. Where have you mentioned the objects of the company? The objects of the company must be mentioned in the articles. So if you are changing the objects of the company, you need to change the articles. For you to change the articles, you have to pass a special resolution by the shareholders of the company. The crux of the matter is how to change the objects and what is the procedure that you have to follow. You have to pass a special resolution by the shareholders of the company. Now the question is, they have a problem of passing a special resolution because for that they have to call a shareholders meeting. Now they can't call a physical meeting because there are travel restrictions. So let's read the balance part of the question also. The directors have consulted you to find out the following. Okay, these are the queries. So we have to answer these three queries here. What type of resolution should be passed to effect the above change? I have already given the answer, special resolution. But you can't just say it's a special resolution. It's a special resolution. It must be supported with the relevant provisions from the Companies Act. Then, can this resolution be passed without getting M involved? Now, M, Manjula, is he an ordinary shareholder? No. Manjula is only a preference shareholder. So, what can we say about it? I'm just giving the answer, then we will look at the relevant provisions. But straight away I can tell you the answer. Manjula is not required in this situation to pass the resolution. You only need the consent of the other two shareholders who are the ordinary shareholders of the company with voting rights. They are Bandula and Sara. Preference shareholders do not have the right to participate ordinary shareholders meeting. Here you have to pass a special resolution by the ordinary shareholders of the company who have the right to vote, that is basically Bandula and Sara. Only those two shareholders voting are required to pass a special resolution. There you require 75% or more under normal circumstances. M's involvement is not important at all because he is not an ordinary shareholder and he has no voting rights when passing a resolution by the shareholders of the company. Then, does the Act have any provision whereby this resolution could be passed without holding a physical meeting? Now, a very important part. Now, there are travel restrictions. In such situations, now you have an urgency. It is urgent for you to change the object clause. Until then, you can't start manufacturing whatever you want here. You can't, because you're required to change the articles of the company by including a new object. For that, you have to pass a special resolution. To pass a special resolution, you have to have a shareholder meeting. But due to the travel restrictions, you can't do that. Then a question arises, can you pass a resolution without having a physical meeting? Can you pass a resolution without having a physical meeting? The answer is, if the article doesn't prohibit, yes, you can pass a resolution without having a physical meeting. We call them shareholders by resolutions by circulation. Yes, you can pass a resolution without having a physical meeting. We call them resolutions by circulation, but that you can do it only if it is not restricted by the articles of the company. Here they have adopted the model articles. The model articles do not restrict a company by passing resolutions by way of circulation. It is possible. But when you are passing a resolution by way of a circulation, there are some important conditions to be met, and those conditions are referred to in the relevant provisions of the Companies Act. So when answering the question, we have to look at those provisions. So with that, you can give a perfect answer to this question. So now let's look at that part also. So explain per the Act the correct legal position with regard to the director's queries. So you can see there are 3 queries. Take one by one. Take the first query, underline the heading, and then explain it. Then the second query, underline, explain. Third query, underline, explain. So then you have given a structured answer without just answering all these queries at one go. Then it will be very clear, and the examiner the markers can easily allocate marks for the explanations that you have given. So let's look at the answer now. So you can see learning outcomes 5.2.1 study text reference pages 89 and 90. So you have to read only 2 pages to answer this question. The relevant provisions from the Companies Act section 143 and 144. Let's look at the provisions and then finally we will look at the answer. Right, 143 and 144. So the first query actually, what type of resolution that you have to pass? A special resolution. Where do they explain a special resolution? Section 143 of the Companies Act. So a resolution shall be a special resolution when it has been passed by a majority. So it explains what a special resolution is. So in your explanation, you explain that while referring to the section. 75% or more of the shareholders entitled to vote, and voting on the question, we need to pass a special resolution. So here it also explains what is the notice period. When you are calling for a meeting to pass a special resolution, you have to give notice. So normally you have to give 15 working days notice. 15 working days notice, and then remember, if you are altering the articles of association, if you now that is not mentioned here, but normally you have to pass an ordinary resolution. But there are certain instances where you have to pass a special resolution, So accordingly, if you are altering the articles of association, if you are changing the objects of the company, you must pass a special resolution here, right? And then answering the other query where they say, if you can't have a physical meeting, can you still pass this resolution? Yes, it can be done. We call it resolution by circulation, or else resolution in lieu of meeting. That means resolution instead of having meeting. Resolution instead of a meeting. In lieu of meeting. We call it resolution by circulation. Now these are the requirements. Not subject to the provision contained in the company's article, a resolution in writing. So there what happens? You don't have a physical meeting. You say, okay, this is the resolution, and you circulate it. By way of an email or by post, you send it to all the ordinary shareholders who have the voting rights. You have to circulate it. Nowadays, we circulate by way of email. So every shareholder, now in this instance, you have only 2 shareholders, Bandula and Sarah. So those 2 shareholders will receive a resolution, and they will be asked whether you are for or against the resolution. They will give you a time period. Within that time period, you have to answer. You have to say whether you vote for the resolution or against. What is the resolution here? You want to amend the objects clause of the company to include a new object stating you can manufacture those face mask and other items. So if you are agreeable to that, you have to vote for the resolution. If you are against, you have to say vote against the resolution, and then you have to send it back to the company on or before the due date. So on the deadline, you are given a deadline. On that date, the company will receive all the resolution with the voting of the shareholders of the company, whether they are for the resolution or against, and accordingly they will decide whether the resolution has been passed. But if you are going to pass a resolution in lieu of meeting, then you need to obtain minimum 85%. Now that you have to explain here. It's an important aspect of the answer here, right? So let's see that part here. Subject to the provisions contained in the company's articles. So if the articles prohibit, you can't do it. But since you have adopted the model articles, there's no problem. You can do this. A resolution in writing signed by not less than 85% of the shareholders. You can reproduce this section when answering the question. 85% of the shareholders who would be entitled to vote. Out of the shareholders who are entitled, out of the shareholders who have the right to vote, 85% of them at a meeting who together hold not less than 85% of the votes entitled to be cast on their resolution shall be as valid as if it had been passed at a meeting of those shareholders. Even though you did not have a physical meeting, if the requirements stated here, if they are satisfied, then you can pass this resolution without calling for a meeting. But for that, you have to get the consent of in writing signed by not less than 85% of the shareholders who would be entitled to vote on the resolution. So that's how you should write this answer. So now let's look at the summary of the answers. So in order to change the object clause of the existing articles of association, the type of resolution required by the Act would be a special resolution. That's the first query. Then a special resolution must be passed by a majority 75%. So then you explain what a special resolution is. Then section 144 of the Act provides for passing of a shareholders resolution. In this case, the special resolution without convening a general meeting. This is also known as a resolution in lieu of meeting or resolution by way of circulation. However, this provision is not available if the articles expressly prohibit it. But since we have adopted the model articles, there is no such prohibition in the model articles. Therefore, you can do this. And then you explain section 144, subsection 1. You can reproduce the section and explain the requirement to be satisfied. So it should be in writing. And finally, this is something that I did not mention, but it's there in the section 144. Once a resolution is passed, within 5 working days, you have to send a copy of the resolution to every shareholder who did not sign it. So there can be, so you circulate the resolution among all the shareholders of the company. So there can be shareholders who don't respond to this resolution at all. They don't say whether they are for or against, they don't reply at all. Then after passing the resolution within 5 working days, the company has a obligation to send the copy of the resolution to all the shareholders who did not sign it. If you don't do that, actually it's considered as an offense committed by the directors and the other officers of the company. So it's a criminal offense actually. So that is how you should write the answer to question number 7, part B. So I hope this was useful. I hope you got an idea how to answer questions in section 2 and section 3. So we are done with that. So we have covered actually 80 marks. Now we are only left with the balance 20 marks where you get 10 MCQs. So now we will look at those MCQs.